Good afternoon, good evening, depending on where you are in Australia, and welcome. Welcome to this evening's sharing it with our Business Benchmark Group and Employsure. And the last 5 months have been an interesting journey, an interesting, unpredictable, and sometimes, I guess, very testing journey. And one of the key areas as it relates to business and I guess the business journey in normal times is the journey called HR, the journey called people, the journey called team. But no two ways about it. Through the COVID period and the last period in Australia and New Zealand since, I guess, late March, it's been an even elevated and more testing, I guess, period. So it's really exciting to have both Gwen and Malcolm from Employsure join us today, this evening, to share on, the back to business. They're getting ready to go back to. So, there's a very definitive pre-COVID period in our business. There is a very evolving and very testing, however, opportunistic period called during COVID. And then there's the post-COVID that we need to be, giving ourselves some latitude and some, affordability to be thinking as leaders and as business owners and also team members. What does our life and or our existence and coexistence in our workplace need to look like as it relates to the post-COVID, I guess, period? And post is not so much that COVID will be finished and it's over and we're back to normal, because there is no normal. This is the normal, and the better we get acquainted and or relatable to that, the better we'll be in controlling the things that we can control. So without further ado, I want to introduce our guests, our formidable guest from Employsure. Malcolm is a regional sales manager across Victoria and New South Wales for Employsure, and he has over 10 years of HR experience with a wide range of industries and size, and his competence not only in the area of HR, but also understanding at a very ground level business and its challenges as it relates to people and the power that makes people and business move forward. So a formidable authority as it relates to HR and understanding business. Gwen Espie is a HR business partner with Employsure and has been in the HR space for over 20 years across small and medium and large business, with a particular focus in industrial relations and employment law. Employsure as an organisation is one of the nation's, if not probably the globe's leading, authority for HR. It has over 150 advisors and consultants across Australia and New Zealand. Employsure has over 25,000 clients across Australia and New Zealand. And I know that's a big number. It makes me feel how Business Benchmark go if we were managing 25,000 clients. And I know one thing's for sure, whatever we're dealing with 150 clients would be done at a times 10 level if we were at 25,000. There is no two ways about it. The standard is a standard, and Employsure has a standard. The presentation will take about 40 to 45 minutes. Please stick around. Malcolm has also organised a prize and a gift at the end of this for everyone who wishes to participate. So please stick around for that. Welcome, Malcolm and Gwen. Thank you for being here. And I know we did this about 3-4 months ago. And seriously, it feels like 2 years ago. And life is certainly evolving and changing and moving in a certain direction. From my experience as it relates to business and HR and the people and the team part, which is a big part. I mean, if you think about our banner here, is a dysfunctional team something you're frustrated with? I mean, it's one of the highest areas of unfulfilled dreams as it relates to businesses going all the way. So you guys are an awesome, business and authorities in the space of HR and employment. What are you guys seeing in the marketplace right now before we get into, the nitty-gritty of our presentation? What are you seeing, Malcolm, as you visit up to 50, 60 businesses every week between you and your team? What are you seeing out in the marketplace?
Yeah, thanks, Stefan. Look, just to give you an idea, I manage probably 40 staff across Australia, and they're out in the field dealing with small, medium businesses every day. And then I have visibility of probably the rest of the country in terms of what's happening in Queensland, WA and SA. And the biggest thing to think, like I've done this role now for 7 years. I've been at Employsure for nearly 7 years. And I sort of thought I had a handle on things, right? I knew most answers to most things around HR, fair work, health and safety, etc. Then this COVID thing hit us. And it's just made things so much more complicated because you've got all your legislation in place from the government, but then you've been overlaid with COVID rules and stand down and JobKeeper, which is ATO legislation. And then you've been overlaid with, you know, business and Victorian government requirements as well. So now I use a lot of experts like Gwen, etc. in these meetings now because things are changing at such a rapid pace. But look, some key things really that we're finding that are challenging for business owners at the moment. Of course, there's the uncertainty about what's going to happen with JobKeeper 2.0. Okay, what's going to happen currently in Victoria at the moment? You know, come the 15th of September. What's that going to look like? Of course. But from a more people perspective, there's some technical things around, you know, businesses wanting to reduce people's hours, right? But without knowing or how to, or whether they need to change things like contracts and what documentation to use. Right, that's important. Because that cuts off things like future litigation and issues in the future. When you can stand down employees, you know, if you're on JobKeeper as a business, it's a lot easier to do that because you just need to give effectively 1 day's notice in a letter. There are, you know, a number of businesses that aren't on JobKeeper, and we're talking, you know, a number of businesses perhaps not in Victoria. So you give an example like a medical centre that can still open. Just because they've had a slowdown in patients coming in to, you know, the practice, and they haven't been ordered to stop work, you know, by the government, may mean that they can't stand down people. So there's these sort of more complexities involved in it. You know, reducing pay of people, either permanently or temporary, the process to go through that, how to document it, consult, and what happens if people like your employees don't want that to happen. What are the repercussions and what then are your options? These are sorts of things we're coming across. Of course, there's a lot of people working from home. I know Gwen's going to touch about, you know, managing people when they're working from home, but, you know, there are a lot of instances where some employers are finding that their employees aren't as accountable now because they're hard to manage and find out exactly what they're doing, right? And they're putting in hours and timesheets and things when perhaps they wouldn't get the return if these people were actually physically in an environment being supervised and seeing the deliverable.
And we're certainly finding that is a cause of, let's say, discomfort. And it's not even the trust thing. It's like, you know, people's familiarity of just walking past their team during the day, had them having a sixth sense, whatever that was, that ensured that they, well, at least they were there, they were present. So that whole reshuffle and little readjustment, which is really, it is one of the interesting adaptable, I guess, challenges as it relates to working from home, working from the office and or the business environment. So that's going to be interesting to hear how Gwen expands on that in a couple of moments. So really looking forward to that. Thank you, Malcolm. I mean, yes, you know, you probably see things from a very different way because it's very HR specific, but it's business. We see it holistically, and HR is a part of the business. So there's definitely plenty of challenges, and you know, there's more challenges to come, in my opinion. Yeah, as we move out of stimulus territory into normal economy, let's say now March onwards, you know, the Tenancy Act is creating some massive stress in various areas too, which is a different conversation. But all these things, I mean, the banks are now asking for business loans that were deferred now to start rolling out. So the pressure, not only in the HR, but all these other little bits and pieces that have been a snowball of COVID are starting to come to moments of truth. And my suspicion, actually, I'll go as far as saying my expectation in the next 90 days, anywhere in Australia and parts of New Zealand, because we're starting to see some ripples there too, there's going to be some massive tension at a level that's going to have people behaving in crazy ways. So, Gwen, before I get too excited about craziness and issues that might have people toe to toe, I'm going to pass over to you because you've got an amazing job this evening, and I look forward to hearing all the updates.
Awesome. Thank you so much, Stefan and Malcolm. Afternoon or evening, everyone. It's evening here in Launceston, where I am, and it's bucking down with rain. So I hope that's not impacting my connection with you all. I'm going to share my screen with you. I'd love to run through some presentation with you. Just bear with me for 1 second. Let's make sure that that's working. And of course, there we go. I'll just get a thumbs up from someone. Malcolm, is that all good? Beautiful.
Yeah, that's working, Gwen. Perfect.
Thank
Malcolm,
you.
you and I will switch off our video. It's over to Gwen.
So there's a few things we want to talk through this evening as a way of trying to give you some support and some ideas and some planning for some of the additional challenges that as business owners, employers that you're facing through this COVID crisis. I don't know if it's a crisis anymore, but the current circumstances that we find ourselves in. So 3 broad topics. What you need to know for the new financial year. Now, obviously, we're a little bit into that year already, and that comes with it all sorts of challenges in any normal year. But I think, as Stefan said, it's this year, I don't know about anyone else, but it feels like it's been going for about 7.5 years so far, and we're only 3/4 of the way through. We want to then talk about hygiene and safety specific to COVID. And for those of you who may be watching or joined from Victoria, that may give you some really valuable information as you prepare to come back, post September the 15th, hoping that, most of the restrictions are lifted and you can start to go back into your businesses again. And then number 3, around engaging employees. Again, in this climate that we're in, many of you will have employees working from home, as we've already flagged, and that comes with its own challenges in terms of not only just supervising and productivity, but how does your employee actually connect with your business when they may not have ever seen another employee from your business face to face? It's all over Zoom or similar kinds of platforms. So let's have a look. I'm going to press the right enter button. There we go. There's Sniffly Steve, as I like to call him. So let's have a talk about, first of all, the minimum wage update. Many of us, and I'm sure you were the same, were hoping and pre the 1st of July that the Fair Work Commission would hold off from any minimum wage update. They have that option in extraordinary circumstances to be able to do that. And we were really hoping that they would freeze it even to not even change until next year in the 1st of July, or at least hold off perhaps until December or something similar. Of course, the ACTU were on a completely different page, and they were seeking a 4% increase across the board, regardless of the industry or business. So what the Commission did was something I'm not sure many people predicted, and it was arguably a good idea and somewhat of a bit of everything. Nowhere near the 4% increase, thankfully. So the national minimum wage was increased by 1.75% or 35 cents per hour. So we now have a national minimum wage of $19.84 per hour for an adult. So generally, if you're 21 or over, or under some awards, there's no junior rate, so that would be the rate for anyone under that award, minimum rate, for example. However, what they did was stage those increases across 3 separate industry award groups that they identified as Group 1, Group 2 and Group 3. Now, I guess ostensibly what they've said in each of those groups is looking at how impacted with those particular industries, or have those particular industries been impacted by COVID. So the first group, or Group 1 awards, had to pass on that 1.75% pay rise on the 1st of July or the first pay period, full pay period after. So they included frontline healthcare, and social assistance workers, teachers and childcare workers, and some other essential services as identified by the Fair Work Commission. The next group don't have to pass that increase on until the 1st of November or the first full pay period after, and they were called Group 2. Construction, manufacturing and a range of other industries, a lot of that same ilk. So the idea being not quite as affected what's happening with Victorian construction and manufacturing industries. And then the third group arguably have been most impacted by COVID, and they don't have to pass the increase on until the 1st of February or the first full pay period after, which are the Group 3 awards. And I don't think there's any surprises here. Accommodation and food services, arts and recreation services, aviation, retail trade, which I used to frequent quite a bit in airports, and tourism. So they don't have to pass the increase on until the 1st of February at this point. So somewhat of a mixed bag of how they made those decisions in respect to the award increases. Of course, regardless of which one of those you fall into, if your employees are already getting paid above the award rate that is attached to their particular position, you don't have to pass that rate on, that increase on at all. If you need to hold that back in order to protect your cash reserves or your cash flow, as long as they're getting whatever the new minimum is for their role, you're doing everything you have to do from a waging perspective. The other big thing that we did not need in 2020 was a court decision with regard to engaging casuals. So there was a decision that came down from the federal courts in late May, WorkPac versus Rosato. And what that did was send a very clear shot across the bow of employers who have casuals engaged in their businesses. And it defined what a casual, well, I guess when a casual is not a casual by this decision. So what it has said is that any casual employee who has an advanced commitment of work on a fairly stable, regular and predictable basis for an indefinite length of time is, for all other intents and purposes, a permanent employee. So what that means is they could then therefore be accessed or request to access or go to Fair Work and lodge a claim to access entitlements like annual leave, personal leave, paid compassionate leave, being paid for public holidays when they're not required to work, and so forth. So of course that opens up all sorts of questions, and some of you may have already been struggling with this and trying to decide if this is an issue for your business. So a couple of things. First of all, nothing has been legislated with respect to this decision as yet, and the government suggested when the decision first came out that they would not legislate based on the decision, but that remains to be seen, of course. However, a couple of issues. What is regular and systematic? And what would be lovely is if the Fair Work Act actually defined that for us, but it doesn't. But Employsure has always advised on this in the same way, pre-decision and post-decision, and we still do. And that is, if you've got a casual employee who can fairly predict that they are going to work next week and the week after and the week after that, and they can't foresee that there'll be very many reasons why they're not going to get regular hours, they're probably regular and systematic. If you've got a roster that you post either electronically or up on a board somewhere, or what have you, and you've got your casuals plotted into that roster, they are probably regular and systematic. Of course, the other question is, well, aren't I already paying them 25% loading to compensate for the lack of annual leave and sick leave and so forth? Now, the answer is yes, you are, presumably, and which is why we're in some respects calling this double dipping, because we're paying 25%, but then the employees also have the option to go to Fair Work if they wish to, or even come to you and say, hey, I want my annual leave. I've been here 4 years as a casual. I don't believe I'm casual. I want my annual leave and my sick leave. So there's a few things that I would strongly recommend if you've got casual employees the first thing, if it's at all possible, make sure that they are what we would call genuine casuals or real casuals. That is, they don't have any predictability of work. They may work next week, maybe they won't. They're very much just on a calling basis. Where that's not possible, and I'm, you know, have thousands of clients that I've dealt with where it's just not possible. It's just a part of their, you know, being flexing up and flexing down their workforce as needed, you know, with seasonal requirements and so forth. Make sure you've got two things in place. Number one, a very clear contract that says that they're a casual employee and that they're receiving a 25% loading to compensate for the lack of annual leave, sick leave and so forth. Make it very, very clear. And then on the pay slip, also have the fact that they're a casual, very clear on there, and break their pay, their hourly rate, or however you might put it, into the two figures, what the base is and then what the loading is. So it's very clear that they are very much getting that compensation already as the casuals. Oh, JobKeeper 2.0. So we obviously have heard from the government that they are going to extend JobKeeper from, so originally it was due to end on September the 27th. And the government have announced they're going to now extend that through till March the 28th of next year. Now, as we speak, that has been introduced to Parliament. I know it was actually going, I understand it was going for debate today. I don't know if any, hadn't seen any news of it being passed immediately before coming on tonight. So exactly what it looks like is still up in the air. And I know Ed Mallard, our Managing Director at Employsure, he's live on Facebook every Friday at 12 o'clock, and he spoke about this last week and said, you know, until we know certainties, it's best to plan as a business as if you're not going to get it, because then at least if you get it and you know, it still remains in place, it's kind of like an added bonus. So, however, there's going to be some differences in how they or how you as a business are eligible. So some businesses who are currently receiving JobKeeper may no longer be eligible, and conversely, some who haven't been may now be. So you've got to be able to show a downturn in the September quarter to remain eligible for payments from October to December, and then again in December from that previous quarter to be able to then receive from January until March. So the requirements at this stage, again, this hasn't gone through Parliament and been legislated. So large businesses with a turnover of plus 1 billion, it's a downturn of 50%. Small businesses, a downturn of 30%, and charities and non-profits, a downturn of 15%. For eligible employees, so previously you would remember for a full-time and part-time employee, permanent employee, they had to have been employed on the 1st of March. That's now been adjusted to the 1st of July. So that allows you know, any employees who came on board between March and July to potentially now be able to meet the criteria to get JobKeeper 2.0. But as I say, still very much up in the air until we get some certainty from legislation. Now, hygiene and safety. I don't know about you, my hands have aged. I'm going to go 35 years in the last 5 months from all the hand washing and the sanitizer that they've been put through. But it's obviously an absolutely critical component of our workplace safety plans and work health safety. So particularly for those of you in Victoria who right now you're not in the workplace or you've got some very, very strong restrictions if you are able to be in your workplaces, these may be of some particular assistance for you. So obviously as restrictions are lifted and you're able to return to your workplaces and your businesses, it's not going to simply be, as it was the first time, a matter of, you know, switching the lights on and going back to work, or does look like. There are some very specific obligations from a work health safety perspective, and different states have got different requirements. So I'd very much encourage you to have a look on your WorkSafe or Safe Work site to look at your specific state requirements as well, if there are any. So different states have different requirements, for example, on how many people you can have in a certain space. That it'd be great if there was a national one, but it's actually state by state. So some thoughts that we're going to have a look at is, I can't afford to spend money modifying my workplace. What other options do I have? You'll see around, particularly in a lot of retail spaces. And I confess, I was watching The Masked Singer the other night, and even between the judges, they've got the big plastic panels up. But that's obviously all costs. My employee is refusing to return to work. What do? I want to spend a little bit of time on this. In my role for Employsure, I've supported quite a few of our clients through that very issue. And of course, worst case, what if an employee or another person in the workplace is actually diagnosed with COVID? What do we do? So first up, you need to do a risk assessment. You'll be all very familiar with these in terms of a work health safety processes that you would normally go through. So before you open your workplace and get your people back in, you need to make sure that it's safe from a COVID perspective. So you need to do a risk assessment, identifying any risks that are current in the workplace that may mean that either COVID is present already, or if it was to become present, the likelihood that it would be transmitted and the seriousness of those consequences if it was transmitted. And that will differ from business to business and industry to industry. Of course, if you've got particularly vulnerable employees in terms of age or health, that's going to have a more serious consequence. Or for example, if you're in the disability sector where you're supporting people with very significant health and issues and disabilities, that may have more serious consequences.
So Gwen, we've got a question here.
Yeah.
From Sam. He's asking, in a small business where it's a little, I'm not sure what the business is, but in a small business, how do we go about the safety assessment, the risk assessment? How do we go about that? What is common sense and what is not common sense? Which just the reference of common sense would mean it's uncommon. So
yes,
what is
indeed.
common sense as it relates to safety and checks that would, good innocent employers or people who are responsible for environments are doing their best to do the right thing? How do we go about that for businesses that are, whether in Victoria on 15th of September onwards or other parts of Australia? How do we go about doing that?
A really great place to start is your Safe Work or Work Safe. They differ from state to state. They'll give you a checklist of some of the things to go through. You can also actually jump on Employsure's website. We also have some documents and some checklists for you to run through. So there'll be things like, how many people, do I have in the space? Can I have in the space? Are people entering my workplace from areas that I may not have control over those particular people? How do I either stop that or control that? What sort of processes do I have to track who is coming into the workplace? Should something occur, for example. And some of the measures that you would put in place, if we jump into the next screen, are quite simple, but really, we're obviously proving that they are very, very effective. And the first of those is obviously hand sanitizer and good soap, hand soap to wash hands in. Who knew that for all our lives we weren't washing our hands correctly, unless we were doctors or surgeons? They probably knew. So you do have an obligation from a work health safety perspective to provide hand sanitizer in your workplace and good antibacterial hand wash or soap, in your bathrooms or kitchens, anywhere where people may be washing their hands. And you might have your hand sanitizer in various locations. Those of you who've been shopping, pre-lockdown, obviously in Melbourne, but elsewhere in the country, you go into one shop, you put hand sanitizer on, you walk out, you go into the next shop, you put hand sanitizer on, so you definitely need to have that, reception and various locations around, perhaps on each desk space and so forth. Whether you need to provide other levels of PPE or personal protective equipment will very much depend on the state you live in and their current requirements, and then your industry. So for example, we're all acutely aware in Victoria at the moment, you must wear a face mask the minute you step outside your home. And so if you've got employees who are able to come to work still, you must be providing them a face mask, even if that means that they're swapping out their own to come to work, put that one on and replace and return home at the end of the day. Whether there are additional things like eye shields, gloves, the full sort of gown will depend on your workplace. From what I understand in Victoria, from my reading, even meat processing plants, they're doing the full gown up at the moment to work. So it will very much depend on your industry. New South Wales, I don't believe, please correct me if I'm wrong, that they've mandated the face mask, but they're strongly urging that people do wear it. So if you've got employees who are requesting it in your workplace and you're in other states where perhaps it's not mandated, I'd recommend providing it to them where that's not too cost inhibitive for you.
Yeah, and I agree with that, Gwen. I think erring on the side of caution, erring on the side of mentally but also physically keeping people safe, because if someone's requesting it, it's not something you want to reject.
Yeah,
not in this environment, in the world that we're living in right now. We do have a question here from Benish. Now, I'm not sure where he's coming from, but however, I'll ask the question, Gwen, if you can help me. Contractors working on ABN are also considered as casual employees. I'm not sure if that's a statement or it's a question. However, trainers and assessor working as casual on ABN will be eligible for permanent employment or annual sick leave after 1 year of service. I'm not sure if there's a question there, an example or a statement, but are you able to confirm are contractors working on ABN also considered as casual employees? Does that make sense for you?
Yeah, if I understand the correct question, please jump in if I get it incorrect. Benish, was it? If they are independent contractors or subcontractors, there are still risks of what we call sham contracting. So a different issue to the issue of casuals, but Fair Work still look at them as an issue around sham contracting. And if Fair Work assess that in fact that person is really an employee, not a contractor, they would call them that sham contracting, and then they may then award against the business and require that employee receive all of those entitlements. I would always recommend have a very close look at your contractors, particularly if you are the only business that they work for. There's a high risk of sham contracting, but it is a very complex area and lots of different factors are considered. And
I agree, Gwen, if you're a subcontractor who's definitely putting in more than 85-90% of your income is derived from one, job provider or person you work with, that there's something about that that's not right. And you either make a decision whether you want to be an employee on that person's team, or they need to make a decision whether you are an employee on their team, and avoid trying to beat the traffic called superannuation, annual leave and sick leave, because in fairness, we're just talking about percentages in the dollar that you're trying to save, but you're actually creating a big hole in your business. Most decent businesses don't need to do that to be in business. It's typically uneducated or businesses that don't have a plan that go about their business in these sort of schemes. So Nicola asks, when is the right time for my team to come back to the office? Can I decide as an employer?
When is it the right time? Is that the question? Yes, you can, providing, there's no restrictions in terms of, government mandate. You need to be both comfortable and certain that it's safe for them to return, but also I think it's a little bit on the next slide. Let me just jump.
Perfect. You are so, this is good. So any question coming in, it's the next slide. I love that.
So whether it's safe, but also you'll need to consider, well, do I actually have enough work for them to do to come back? So,
Well, yeah, and then what happens if an employee does not want to return? I mean, we have clients right now, Gwen, that for whatever is the motivation or the reality,
their employees
I don't want to go back to the working place. I'm not coming back to the the restaurants or even though it's only doing takeaway now. I don't want to come back to the retail store because it's the safety methods are not right. Blah blah blah.
Let me
What do you do? What do you do as an employer if the employee, and in all fairness, but they certainly have a story there, don't want to come back?
So there's a couple of things. First of all, obviously you'll be talking with your employee if they have a legitimate reason why they don't want to come back. So perhaps they have an underlying medical issue themselves that will make them particularly vulnerable, or perhaps they have someone in very close contact in their world, so someone they live with generally or care for who is particularly vulnerable. If that's the case, you would invite them to get medical evidence to provide to you, at which case then you may, in consultation with them, discuss other options. Can they work from home? Is it the kind of job they can or continue to work from home? If they can't, then they may need to take a period of leave, whether it's annual leave or long service leave or unpaid leave, depending on what options are available to them. If those two things don't exist, if it's not about health, if it's just about, either a fear or, dare I say, because I have dealt with some of these for our clients, they're just quite enjoying the JobKeeper holiday and the Netflix marathons during the day. If that's the reason why they're not returning to work, you've got a couple of options. If they're casuals and you're getting JobKeeper for them, you have said to the tax office that this person is a regular and systematic casual. Now, if they are refusing shifts now, you can provide for them. I would argue they are no longer regular and systematic, and you could be making that call to the tax office and saying, this person is no longer eligible for JobKeeper. You might want to give your employee fair warning to give them an option of making that last minute decision to do the right thing, but I have certainly recommended that to a lot of our clients. Alternatively, if they are either full-time or part-time, so permanent and receiving, whether or not you're receiving JobKeeper for them, that is then a disciplinary matter. If they are not returning to work, you have work for them to do, and they're refusing to return, you would, be well entitled to commence a disciplinary process. And because what they're doing is refusing a reasonable management directive, and that's the very basis of their contract of employment with you, to follow all reasonable management directives.
And I see that as the tricky sort of line, do we, don't we, should we, shouldn't we? I see that as the trickiest. And again, my recommendation to many of our clients is you probably don't have the skill set or the ability to get to the truth as to what you do here. And then reaching out to, I guess, their HR consultants and or an Employsure as an example, which is formidable in this space. You get some real clarity as to what you can and what you can't do. So what would you recommend? I mean, you mentioned earlier business owners can go to employers, or even employees can go to the Employsure website, and there's some bits and pieces that obviously gives them some answers. But what would you recommend over and beyond that? I mean, I personally would recommend this is not a place where you want to get it wrong, or should you even think of winging it. You've got to get the education. This is a very fluid and transient situation.
It is. And lots of people said to me at the beginning of this crisis that surely all bets are off right now and we can pretty much do what we want as businesses, and, the community and Fair Work are going to be understanding because, we're in a major crisis here. The reality is, and I felt it then and have been sadly proven correct, that two things. Fair Work are not taking a soft fine at all through this crisis. And unfair dismissal claims have actually increased by something like 70%. So employees are increasingly, understandably, probably litigious because they're in self-preservation mode. So if they've lost their job for whatever reason, they're frightened they're not going to get another one. So they're going to try and access money in some way or shape or form that might be open to them. And while they may not be successful, it just creates another level of stress that you don't need right now as a business owner. So definitely I would highly, definitely say don't wing it. Reach out to an expert in the area. Obviously our clients come to us. We've got a 24/7 advice line, which I think our phone lines have just about burned out over the past 5 months because of all of these issues that we've been advising on.
And just on that, I mean, just when you're, your brief on the business is you have 150 advisors and consultants, Gwen. What exactly does 150 advisors and consultants do?
Well, if the advisors,
Employsure, that is.
yes. So we've got advisors are a work, health, safety and industrial relations specialists who answer the phone. So we've got a 24/7 advice line. So literally, from any time in the day or night, day or weekends or weekdays, whatever, our clients can call and say, help, I've got a problem, what do I do? And the advisor will then talk through the issue, present the safest options to follow, and then back that up with either appropriate documentation, like a letter to invite the employee to a disciplinary meeting, or the relevant legislation, whatever it might be, so that the employer, the client, can then, they know that they've got everything they need to be able to then follow through. And then they'll take one step, they'll do that bit, and then they'll call us again, call the advisor again, and get the next step underway.
So as this COVID scenario and situation, because we're in during COVID now, as this is evolving and rolling out and the intricacies of, what is, what isn't, your advisors and consultants are constantly at the front end of being in the loop.
We are. So we have some amazing learning and development people in various states, I think, who their job is to glean all of the new information as it comes to hand, whether it's award changes, fair work additions, legislative changes, state by state changes, and then provide that out to the network, to all of us who act in those roles, to be able to appropriately advise. And I know
I'm sort of going on a bit of a tangent here, but if I'm not mistaken, any advice, if you're a client of Employsure, via the consultants and or advisory team, if you follow that advice as is given and it goes against you, you have an insurance that covers any, let's call it unfair or any penalties that may arise of not, you're executing on the advice and you, let's say, are faced with an unfair dismissal or an unfair situation, which may have a penalty of monies. Those monies are underwritten and or backed by an insurance policy. Is that right?
Yeah, let me clarify that. Yes, Stefan. What we have is a mutual. It's a fund. And our clients are members of this fund. Now, this fund pays out on settlements such as unfair dismissal claims, general protection claims, legal representation, etc. When it comes to health and safety fines, legal representation, depending on which state you're in. New South Wales, they've currently changed the laws around third-party entities being able to cover fines around health and safety. We pay out these settlements, or this fund does, in accordance with what's called a product disclosure statement. And that's all regulated by ASIC and a financial services guide. So it's very intertwined, Stefan. The documentation that Gwen talks about, the contracts, your policies, your handbooks, the letters, and then you need to follow, a certain process that we're talking about, because there's certain order of things you need to do things, certain letters, certain consultation processes around all these. And if you follow our guidance and help, then yes, you are protected in accordance with that product disclosure statement. Like an insurance, but it's now it's what's called a mutual. Okay?
Thank you for that clarity, because again, I sort of I understand that, not to a point of intimacy as you've just described it, but I just feel in this environment that's ever so changing and ever so challenging, as I shared at the start of this meeting, the ability to have a team of advisors and consultants that are right at the front end, right on the edge, almost being a shield of minimising dumb tax. I think it's a formidable, I guess, reference point for something that's really big. I mean, just listening to Malcolm just there, it's like, holy shit, that's a lot of stuff for trying to wing it as a business owner and try and make your business run in every other area that needs your focus too. So back to you, Gwen. Thank you for, again, just expanding on that question that Nicola or Noella
not
had
at all.
asked.
Now, I think there was, I'm not sure that we hadn't finished that question. I think there was another question that came through the chat I just saw. What's the best way to communicate about returning to work? Just to round that off. Look, an email is perfectly fine. I would always recommend having a verbal conversation first if you can. So perhaps give them a call or whatever, and then follow that up in writing. And really, you don't need to provide a lot of notice, a day or two, 3 maybe, that you know, they're required back at work, and what time and so forth. And of course, you would have done your risk assessment by then and have everything set up safely. The other thing I just wanted to cover off, if you don't have enough work right now to keep everyone gainfully employed, but you don't want to shed these employees because, you know, you have every belief and hope that, you know, given a few months down the track, things will get back up closer to where they were pre-COVID. You can do 2 things. If you're on JobKeeper, you've got the JobKeeper enabling directions. At this stage still, we're not clear whether they will go into JobKeeper 2.0. So you can direct your employees to take reduced hours or take annual leave, for example. If you're not getting JobKeeper for them, then go through a consultation process. You know, can they take a reduction of hours temporarily? Put that in writing. Can they take some annual leave or some long service leave or even unpaid leave, and get that in writing? And obviously you're conversing during this time, helping them to understand the reason that you're doing that is to try and protect their job long term. That what you're trying to avoid is a redundancy process, because you have every hope and belief that you will be able to bring them back full time or to their normal role at some time in the future, and that is your intent. Now, oops, my mouse has moved off my button. There we go. I want to talk about just briefly with you, as I am conscious of time, and I know you're all very busy people. We've talked about some of these common types of your employees, the types of employees. So we flagged the 2 problem children. One is the casual and one is the independent contractor. Just really briefly, if you've got part-time employees of any description, so and part-time employees, generally someone who's permanent but is working under 38 hours a week, check your award or your agreement, your enterprise agreement, because it should, and certainly your award does, enterprise agreement should speak to how you can treat a part-time employee. Most critically, most of the time that award or agreement will say that you must agree on the number of hours that employee works per week and when they work those hours. So what days and what hours they are on given days. And then if they work in excess of those hours, you are generally automatically required to pay them overtime. So if they normally work 20 and for some reason they've worked 22 this week, those additional 2 hours are normally overtime. And if you're not aware of that and you're not paying that as such, then you've got risks of underpayment claims coming back to you at some point, and an employee has 6 years to lodge an underpayment claim from when it happened. So that's, you know, quite a long period of time. Now, there is a sort of a protection in there for you that you can also consult and have the employee agree in writing that they will work, you know, in excess of their normal hours at normal pay, but you need to get that in writing every time it happens in order for that, it's just called a variation, in order for that to protect you from the underpayment claim. So contracts, I think if there was ever a time that contracts are critical, it's, excuse me, right now. So a couple of things in terms of the contract cycle. They're not a set and forget document. So, you know, someone started working for you 3 years ago, you gave them a contract and that was the last you know, thought about a contract. So a few things. A contract is a legally binding document for both parties, the employee and the employer. So anything inside that document is legally binding. So there are some things that you should include very critically, and we'll talk about those in a moment. You should review it on a regular basis, and we'll talk about why in a moment as well. And when a contract is terminated, so generally that means someone's resigned, or in some circumstances you've terminated their employment, perhaps for misconduct, or you've made their position redundant. There's some steps that are really a good idea to follow to make sure that you've got everything neatly tied off at the end of an employment agreement with an employee. So when you're creating a contract, and obviously we do these in our sleep here at Employsure, you need to include things that are related to legislation. So you need to refer to the fact that they get leave, for example, and what rate of pay they're going to receive. There's some standard terms that are really critical to put in there. So what type of employment? Are they full-time? Are they part-time? Are they casual? Is it fixed term for a very, you know, a specific time frame? That they've got a commitment to carry out the duties that you require of them and to follow policies. You'll talk about their hours of work, how their remuneration is calculated. So they're getting an hourly rate, but then they'll get every penalty and allowance and so forth under the award, or are you paying them an hourly rate that is inclusive of all of those, or an annual salary? You'll need to put in there any verbal agreements that you may have already made with them regarding additional benefits on things like that. And of course, there's some common law rules and implied terms that need to go in there as well, or good idea to go in there. For example, what your reasons that they may be face disciplinary action, for example. This is why you should regularly review your contracts. If there is a substantial amendment to an employee's role or the entitlements that they are receiving. So right now, if you have a verbal agreement with your employee to reduce their hours, let's say from 38 to 20, for example, but you haven't documented that in any way, that poses a risk to you as a business owner that at some point you may face an underpayment claim. Because even though you know that you've made that verbal contract, if you haven't got it in writing, that contract stands. It's legally binding and that original contract stands. If there's changes in terms to, you know, things like wages, allowances, overtime and other benefits, important to update the contract. Changes in legislation. So there's been a big one of recent days. You may all be aware, it's a good time to flag it. About a year ago, courtesy of the Cadbury factory workers down here in Hobart, the way that we accrued and paid annual leave was changed, and every part-time worker, where they used to get pro rata paid personal leave, they then were entitled to 10 days. That's just been reversed in courts. So it went into legislation, now it's reversed out again after an appeal. But that was a significant change that needed to be updated the first time and now again in your contracts. And of course, if you negotiate any other variations, such as you know, you're going to give them a $100 a week petrol allowance or something like that, in recognition of the fact that they are driving their car a lot, or whatever it might be. Stephanie, did you look like you have a question before I go off?
No, just again, you know, contracts and agreements, and you know, particularly for many of our clients, because I mean, this presentation is going to go up to our resource centre, and many of our clients will be looking at this over the next few days and over the weekend. It is important, like everything else. It's almost like a spring clean. Just be up to date. Be okay to have it looked at and or reviewed. Be curious, be open-minded, get some feedback. Almost treat it as a health check. You know, just make sure you're up to speed with all the bits and pieces.
Absolutely.
I mean, you know, a little bit of, I guess, award creep, otherwise known in other areas as scope creep, can have you behind the eight ball, unbeknown to you. It was never deliberate. It happened.
Absolutely.
And now
Absolutely.
you're in a situation where it can be a little embarrassing if you've got a good relationship with your team members. But in fairness, it's hygiene.
Yes,
Spring
indeed.
clean.
Because as we speak, for example, I don't know how many may be watching who are in the construction industry, but the Building and Construction General On-Site Award has gone through massive changes in the last 3 months. Massive. Yeah. But you can't possibly know what you don't know without getting those, that reviewed information through. And so, in respect to what our consultants do, so advisors answer the phone, consultants actually go either on site or Zoom or similar to our new clients and help review all of those documents that are already in place if you have them, and make sure that what you've got is compliant and provide compliant documentation for you where necessary.
Yeah, no, great, and that's what I just wanted to add. Any more questions? Okay. So
I just had a little look there.
Okay, over to you, Gwen. I know must be getting almost to the end.
Yeah, we are indeed. So very quickly, if you're engaging your employees right now, and particularly if they're not going to be working where you normally have them, if you're going to have them in some remote location like home, we need to, I guess, double down on what we always do and just make it, absolutely everything just above board, perfectly executed. So first of all, make sure they feel like you're expecting them and that they are welcome. So make sure the rest of your team or employees are aware of this new person and who they are and what they are expected to do. That either their manager or supervisor, if appropriate, or them as individuals have what they need to be able to do already in place. I'm sure we've all entered workplaces sometime in our career as new employees and our login is wrong or hasn't been made yet, or we haven't got a fuel card for the car, or don't have a desk, whatever it might be, and it's not a great first day or first week. And I think that we could probably double and triple that right now if you're having to start your first day by walking back into your bedroom and sitting at a desk to work on remotely. Maybe look at assigning someone, not a manager or a supervisor, but a peer that they can just go to ask all those little questions that you can't possibly know the answer to in those first few weeks, but that you may not want to ask a manager. You may feel a little bit embarrassed, or they may just feel like, I think I'm meant to know that, but someone that they can go to with that. That also then allows their manager to just get on with actually managing the role rather than all those little nitty-gritty details. Then do the introductions. Just the other day, we had a new team member start in my team. We are Vic Taz consultants, and I'm a business partner, but I belong to the consultants team. And there was a new face that popped up on the Zoom meeting, but we already knew that they were there. So that was just a formal introduction, which was really good. And they got to meet all of us as well. And now more than ever, even if you're hiring someone who's absolutely already competent in the job that you're hiring them to do, don't throw them in the deep end. There's potential for the overwhelm to come much faster and harder than when they're in an office space or in a workspace surrounded by people that they can put their hands up if they're drowning a little bit. Much different as we speak right now. I think a question just dropped in, if I'm not mistaken.
Yep.
Where did it go?
Can you change a contract of employment with the updated terms for existing employees?
You can. You can't change the underlying things that you've already agreed to with them. So you can't make a significant change without their agreement. So if you're just updating the contract, and perhaps adding in new legislative requirements and things like that, that's not changing their contract, that's just bringing it up to speed. But if, for example, you're removing a significant benefit, like let's say they had access to a motor vehicle and now you're taking that out, that's a significant change. And so that's something that you would have needed to have done in consultation. if that's, if you've just updated it to, accommodate the required changes, ostensibly, if they don't sign it, but they've received it, you've explained it to them, and you can demonstrate that, through your documentation. When I'm talking to clients, one of the things I do sometimes is help them roll out their new contracts to employees. I call it Wonder Woman Inc. So if they choose to sign it, but we know that they've got it, and they come back to work next week and next fortnight, and you continue to pay them, they've agreed to the terms of that contract. And so I can't speak apparently. Essentially, they've signed that in Wonder Woman Inc. is what I say to them. So yes, you can. Look, we're all over the social medias. Ed Mallett, our managing director, has become a bit of a social media darling and a breakfast TV darling. For those of you who watch, I don't go to get wrong, Sunrise, and some of the news editions as well. 12 o'clock tomorrow, he'll be live on Facebook. I'd encourage you to jump on. Otherwise, I am going to turn it over to Malcolm.
Great, thanks Gwen. What I'd like to do is finish off, I've got 2 slides to go through. One is just very briefly to help people understand how Employsure support businesses through this current environment at the moment. And then secondly, a bit of a freebie. So just in terms of what we do, we're supporting about 23,000 businesses across Australia at the moment, the owners and directors, and we're helping them navigate through all this complexity of managing people, staff, health and safety. What we do is that we provide a consultancy compliancy review with people like Gwen, who look at your current situation, the way you engage people, the documentation you have in place, and we review, we recommend, we redraft if needed. All right, we can draft documentation from scratch if you don't have it or you really need it. Okay. Secondly, what we do is we keep you up to date then with changes of legislation. So you don't need to worry that legislation's changing and your documentation's getting out of date. Okay. We then provide unlimited advice. So wouldn't it be great when you have all these questions about poor performing employees, people not turning up to work, allowances, interpretation of the award, that you can have someone like Gwen on the phone helping you out, because that's what our advisors do. It's unlimited guidance and help around employment relations, health and safety, COVID safe plans, written letters for you, and you don't pay for it like a law firm or an HR consultant on an hourly basis. It's unlimited guidance and help. What Stefan spoke about then is also, if you're a client, you get a claim against you, work safe, take you to court, fine, prosecute, you are covered by Employsure Protect, which basically, and our legal firm, or Spark Hillmore, which is another large law firm. They basically represent our clients and we say we've got your back. And their legal fees are covered by this large not-for-profit mutual, which I mentioned we pay out in accordance with the product disclosure statement. So it gives businesses not only peace of mind around the documentation, around getting live advice around the changing legislation at the moment, but if there's a claim against the business, they have a level of protection there as well. If I could get you to go to the next slide, Gwen, please. What we've done in conjunction with Stefan and Business Benchmark Group is we've actually offered some help at the moment to businesses. Hopefully you've taken from this, from Gwen tonight, the importance of your documentation, your letters, your health and safety system, particularly in this environment. So over the next couple of weeks, if you want either one, what's called a contract check, I think that may be loaded up next, Rob, on the screen. We can give you basically a review of one of your contracts, and we'll give you some professional advice about, are there any non-compliance issues there with the Fair Work Act? Also, basically help you recommend to you commercial terms within the contract that you should have to help you and your business, right? To protect yourself. So there we go. We've got it up on the screen now, a contract check. That will be provided for you free for those people that are currently on this call. Or alternatively, we can do a safe check. A lot of businesses at the moment, aren't updating, or they've got behind around their health and safety systems. We can review the current practices, policies, systems that you've got in place, give you some ideas about where you're falling short, areas of non-compliance, and actually report on that health and safety status for you. So normally we charge $500 for these two pieces of work, all right? So you, the way to activate this, if we go back one step now to the previous slide.
So what we'll do, Malcolm, we'll also send this out to everyone in our client base. We're going to send that offer out if that's okay with you. We'll make sure if you're okay with this, we're going to put your details on that. I would prefer people come through you as it relates to making a commitment, and I know I can confidently assume that you will ensure that they end up with the right advisor, and I'd be much appreciative if you can navigate that for us for our client base. So we're gonna send to everyone that offer, and thank you for making that applicable for all our clients. We're also going to put your details on it because I would prefer they come through you.
That's fine. Yep, and they quote a code on that as well. So
and your quoted code.
Write this down.
You don't tomorrow say Stefan who? Which I know you would, mate, and I appreciate everything you've done here tonight again, and everything you do for many of our clients on the journey. So, it's fair to say what you and Employsure do is an undeniable important part of business. It ensures that no one is blindsided and or bamboozled, and the muscle that Employsure flexes, which is again 150 consultants and advisors deep, 25,000 clients or so across Australia and New Zealand and in other parts of the world. It's a formidable beast, and the investment to keep your head sleeping okay at night, as it relates to HR and being at the front end of not having this being an area of assumption, an area of surprise, is critical, and I think it's a success trait for most businesses that are mature enough to understand it's a shekel against the dollars, and it keeps you sleeping at night. So I appreciate you making this offer applicable for our community at Business Benchmark Group. Gwen, I thank you again for taking time out of your family time to share here tonight as well. I know we've gone a little bit over, and we've certainly embraced the questions that have come through, and there'll be most likely a few more coming through over the next 3, 4, 5 days. And in fairness, everyone's a little webinar out. So we put this up on our resource centre, and there'll be plenty of our clients that will go to it, and even people that are not clients yet. And we're going to ensure that everyone gets an opportunity to reach out and get their clarity as to whether they are or they're not in a position of being in control as it relates to their HR approach.
Of course, if you've got any questions you want to shoot through to me, happy to send back a response anytime.
Yeah, thank you. We're starting to grow our presence in Tasmania as well right now, and other parts of Australia. So I look forward to having a conversation with you offline regarding that. And Malcolm, thank you once again for everything you do. You're always available, and you are 100% customer centric, and that's why having anyone that reaches out to you via Business Benchmark directly to you has me having peace of mind that they're in good hands.
Thank you, Stefan, for those words, and also, for allowing us to speak to your network tonight. And we really hope that we've, at least given you some ideas, food for thought about how to manage coming now over the next incoming months.
It's been super.
Even for that, yeah.
Okay, I'm feeling a rumbling stomach coming on. And I need to go and get my Popeye spinach in the system.
Nice.
Thank you so much for everything you do.
Good night.
Round of applause for you guys.
Good night,
Thanks so much,
everyone.
Thank you, Gwen. Thank you, Malcolm. Good evening,
Thank you.
everybody. And we'll
Bye.
speak very soon. Thank you.
Absolute pleasure.
Thank you.
Bye.